We are pleased to have with us Ms. Lisa Greaves. She is the Data Protection Commissioner, and we now invite her to present her remarks.
Thank you. Good evening. Thank you, Mariette. I would like to thank Mr. Dwight Robinson, President of BISSA. I'd like to thank Ms. Margaret Leon, President of BIPA, for inviting me, and a special thanks to Mr. David Gittins, who reached out and invited me to this event. Thank you and good evening. My name is Lisa Greaves. I'm the Data Protection Commissioner, and I'm an attorney at law. And I'm going to be presenting today on how to establish a regulatory framework within the data protection space. I'm looking at risk and the regulatory framework for data protection. And it's apt that we're looking at ransomware and data privacy this evening, because risk in the data protection space will involve things like ransomware. Now, the question you may ask is, what is risk? First, we're going to look at the foundation of the regulatory framework, what is risk, and then a risk-based approach to regulation. Now, like other regulatory frameworks in Barbados, the regulatory framework within the data protection space is surrounded by one central concept. For data protection, it is the fundamental and constitutional right of persons to have a right to privacy. And that right to privacy extends to the right to have their data protected. So basically, the Data Protection Act, which brings into being the Data Protection Commission, and my function as the Data Protection Commissioner as regulator, is built and surrounded on that right to privacy. So you have the legislative framework, which is the act. You have the regulations, which will come under the act. And then you have the regulatory framework, all working together to ensure that people's rights, data subjects, everyday people, as well as cybersecurity experts like yourself, non-techie people or tech novices, everybody has a right to have their privacy, their data protected, and a right to privacy. So what is risk? Now, risk is interesting. Risk is the same in every regulatory framework. It is the intersection between threat and vulnerability. It is where these two meet. So ransomware would obviously fall in the category of a threat, and vulnerability would be looking at the systems that are in place to protect against these very threats. And when these two intersect, you have risk. And this leads to taking what all regulatory frameworks speak about, which is a risk-based approach to supervision. A risk-based approach to supervision and guidance. Risk-based versus rules-based, meaning you cannot take a prescriptive or a tick box approach. You cannot just ask, what do I have to do if I'm processing data to make sure that data is protected? You cannot look to the commission to say to you, do this or do that. You have to take a risk-based approach, which essentially means that every entity, every sector, and the Data Protection Commission as the supervisor has to have risk be the foundation of everything that they're doing. Risk informs every action. So everyone at every level, whether entity, sectoral, or supervisory, must assess and understand risk, must be able to identify the risk, measure the risk, control the risk, and monitor the risk. What is the risk in data protection? It's simple. The risk that someone's data is breached. Now, threats will always occur. Persons will always be hacking. There will always be people coming, trying to get data, because everyone knows data is the new gold. But the question is, what measures were put in place to mitigate this risk? And how effective were those measures? And what the commission will do as regulator is take a risk-based approach to regulation. So all the supervisory strategies, the plans, the supervisory tools, the nature, intensity, focus of supervision, going in for data audits to see how data is being processed, interacting with controllers and processors who are registered on the app. all of that will be informed by risk. So every individual, every entity who processes personal data, and more importantly, those who process sensitive personal data, things like financial records, anything to do with people's political opinions, their ethnicity, their race, that's considered sensitive personal data, health records, all have to look at it from a risk perspective. What is the risk in my operations, and what must I do to mitigate that risk? And that is essentially how the regulatory framework within the data protection space will develop and is being developed. So all the outreach, the actions, sanctions, where appropriate, we're far away from sanctions, guidance, feedback, everything that the Data Protection Commission has been empowered with under the Data Protection Act will be informed by risk. It will essentially mean that entities, sectors, and the commission are essentially carrying out their own risk assessment of what the risk is like, to ensure that you have a framework that is strong, that is robust, that you know has taken an objective and has an objective approach to assessing its risk and doing its very best to put the measures in place to mitigate that risk. Thank you so much. That was essentially my opening remarks and a brief introduction to the BISSA and the BIPA audience to speak about the Data Protection Commission and its role as a regulator in the data protection space. Thank you.